Report of the Center-State Relations Inquiry Committee, Government of Tamil Nadu, 1971, read by Ramani. Chapter 18, Seabed under Territorial Waters. Under Section 172 1A of the Government of India Act 1935, all lands situate in a province vested in the Crown for the purposes of the government of the province. The territory of a state consists not only of the land within its boundaries, but it includes national waters and, in the case of maritime states, territorial waters also. Waters in lakes, rivers, and canals are deemed to be national waters. Territorial waters are waters contained in the maritime zone or belt surrounding a state. The seabed belongs to the littoral state absolutely in the same manner as its lands. It has the fullest dominion over it. It alone is entitled to the minerals therein, and it is entitled to construct tunnels thereunder. Article 1(2) of the Constitution enacts that the states and the territories thereof shall be as specified in the first schedule to the Constitution. That schedule does not exclude the seabed and the territorial waters from the territories of the states. Article 297, however, vests in the Union all lands, minerals, and other things of value underlying the ocean within the territorial waters of the country. Had Article 297 not been included in the Constitution, the bed of the sea and the subsoil beneath the territorial waters would have been under the ownership of the states with the right to exploit both the surface and the subsoil. No provision to Article 297 was included in the draft Constitution prepared by the Constitutional Advisor in October 1947. Nor even did the draft Constitution prepared by the Drafting Committee in February 1948 contain any corresponding provision. The idea seems to have originated with Thiru R.R. Divakar and Thiru S.V. Krishnamurti Rao, who suggested the insertion of an entry in the Union list relating to the ownership of and dominion over lands, minerals, and other things of value underlying the ocean seaward of the ordinary low water mark on the coast, extending to 3 nautical miles. It was pointed out with reference to the suggestion that if the intention was that the ownership of and dominion over lands, minerals, and other things of value underlying the ocean within territorial waters should vest in the Union and not in the maritime states, a specific provision should be made in the Constitution to that effect. The drafting committee decided to insert the requisite provision in the draft Constitution. Introducing the new provision numbered as Draft Article 271A on the 15th of June 1949, Dr. Ambedkar told the Constituent Assembly, quote, "We are going to have integrated into the territory of India several states which are for the time being maritime states, and it may be quite possible for such states to raise the issue that anything underlying the ocean within the territorial waters of such states will vest in them. In order to negative any such contention being raised hereafter, it is necessary to incorporate this article." Unquote. Thiru A. Thanu Pillai pointed out that although a certain amount of control in respect of territorial waters should vest in the Union, all property and things within the territorial waters should not vest in the Union. He pleaded that the maritime states should not be divested of the right to minerals, etc., in territorial waters. Dr. Ambedkar, in his reply to the discussion, again dealt with the object of the new provision. He said, quote, "Ordinarily, it's always understood that the territorial limits of a state are not confined to the actual physical territory, but extend beyond that for 3 miles in the sea. That's a general proposition which has been accepted by international law. Now, the fear is, I do not want to hide this fact, that if certain maritime states, such as, for instance, Cochin, Travancore, or Kutch, came into the Indian Union, unless there was a specific provision in the Constitution, such as the one we are trying to introduce, it would be still open to them to say, our accession gives jurisdiction to the central government over the physical territory of the original states, but a territory which includes territorial waters is free from the jurisdiction of the central government, and we will still continue to exercise our jurisdiction not only on the physical territory but also on the territorial waters, which, according to the international law and according to our original status before accession, belong to us. We therefore want to state expressly in the Constitution that when any maritime states join the Indian Union, the territorial waters of that maritime state will go to the central government. That kind of question shall never be subject to any kind of dispute or adjudication. That's the reason why we want to make this provision in Article 271A, unquote. It will be seen from the speeches of Dr. Ambedkar that under international law, the territorial waters and the land underneath them vest in the adjoining states and not in the federal government, and that the only object of the article was to extinguish the right of Indian states to the seabed and the territorial waters. Again, according to Dr. Ambedkar, the intention behind Article 297 was that the territorial waters themselves, and not merely the seabed below those waters, should go to the Union government. But the Madras High Court in AMSSVM and Co. versus State of Madras, ILR 1953, Madras 1175, at page 1192, has, while interpreting Article 297, categorically stated, quote, under this provision, what vests in the Union is the bed of the sea beneath the territorial waters, and not the waters themselves, and in law, the two do not stand in the same position. Under the Constitution, fisheries is an item included in the state list. Fishing and fisheries beyond territorial waters is in the Union list. The Madras High Court, in the decision referred to above, has pointed out that under Entry 21 of the state list, the state legislature is competent to enact laws in respect of fisheries in territorial waters. Article 297 refers to the continental shelf also. But for Article 297, the seabed under the territorial waters and minerals therein would vest in the maritime states. This is the present position prevalent in the United States of America. We have suggested in another chapter that the legislative entries relating to oil fields, mineral oil resources, petroleum, mines and minerals in the Union list should be transferred to the state list. Consistent with this suggestion, we recommend that Article 297 may be altered so as to restrict it to the continental shelf of the country. In that event, the seabed and minerals therein under the territorial waters will vest in the states. It may be pointed out here that in the United States of America, an Act of 1953 empowers the federal government to explore and develop natural resources in the seabed underlying the continental shelf. Our suggestion, if implemented, will bring Article 297 into accord with the position as it now obtains in the United States of America. It may be mentioned that Dr. Ambedkar's reason no longer holds good, as there are no Part B states now.